Thank you, Director Chopra, for your testimony and time today on this lengthy hearing. As my colleagues have expressed, many of us have heard from our constituents about concerns regarding the Bureau, its regulatory overreach, and its lack of transparency. From regulation by enforcement to undue burdens for small businesses, it's clear the CFPB, as it's currently operating, it's not serving consumers or small business owners. Director Chopra, the CFPB is unique among federal agencies. Not only is the Bureau not subject to the appropriations process, it also does not have an executive board to weigh in on decision-making and does not have an inspector general to root out waste, fraud, and abuse. Effectively, you oversee the Bureau without any meaningful or direct oversight. As a result, there's a remarkable lack of transparency with the CFPB, which is something I and many of my colleagues would like to see fixed. Director Chopra, in May of 2022, you unilaterally issued an interpretive rule without statutory authority expanding the authority of states to pursue and enforce violations of federal consumer protection laws under the CFPA. The CFPB further promoted this additional enforcement activity by assuring states they may bring an enforcement action to stop or remediate harm that is not addressed by a CFPB enforcement action against the same entity. And the CFPB announced it would enter into more than 20 agreements with states' Attorney General's office. While Congress intended for the CFPB to enforce federal consumer financial laws and protect consumers in the marketplace, it did not intend for the CFPB to intimidate companies by conspiring with state agencies to pursue duplicative and sometimes competing and confusing enforcement actions. The Dodd-Frank Act limits attorneys general in bringing federal enforcement actions, and while state attorneys general may enforce the CFPA in cases where CFPB has not, the law does not allow for a state attorney general to become a party to an existing CFPB enforcement action. It's therefore inappropriate for the CFPB to recruit a state attorney general that's not otherwise investigating a company to pursue enforcement as a means of intimidation. Moreover, the effect of your May 19, 2022 interpretive rule is different from solely enforcing the law. It's more akin to deputizing state attorneys general to enforce the CFPA on behalf of the CFPB, something Congress did not authorize. How many actions has the CFPB initiated with state AGs since the issuance of your interpretive rule?
I don't have an exact number, but I don't think it deviates from prior practice across
Would you check to see, I'm sorry, reclaiming my time, would you check to see and confirm in writing how many actions the CFPB has initiated?
Yes.
Okay. Of these actions...
when you say initiated enforcement action.
Since the issuance of your interpretive rule with state AGs. Yeah. Of these actions, can you explain to me why you involved a state AG as opposed to prosecuting the action solely under your own authority?
Well, we saw in the lead up to the financial crisis about how preemption, deleting state law, had very negative effects to protecting inside state borders. It is very common. The DOJ, the FTC, and others regularly partner with state AGs and state agencies. Our statute requires us to coordinate. We have MOUs with states and others. So I think we're trying to do exactly what the law is saying.
Reclaiming my time. First of all, I just want to reiterate that Congress did not authorize the outside use of attorneys general in this instance. Does the
Congress
CFPB
explicitly authorized.
Does the CFPB engage in forum analysis when determining whether to institute an action in its own capacity or to engage a state AG?
We look at enforcement actions based on the company's place of business, whether we have any co-plaintiffs. We do exactly, I think, what every other law enforcement agency does.
The result of this, though, this interpretive rule, in some instances has resulted in competing enforcement actions between what the state's actions are and what the CFPB's actions are. The Administrative Procedure Act provides interested parties with notice and an opportunity to be heard and the right to seek judicial review of agency action. Why did you choose to issue an interpretive rule regarding actions by state AGs as opposed to engaging in notice and comment rulemaking?
Well, it restated what the law already authorized. So this was not creating any new obligations on the public, but we were trying to be very clear that it is not, the CFPB does not have a monopoly on consumer protection.
Director Chopra, I've got one last question for you.
Sure.
By using the mechanism of an interpretive rule, haven't you avoided the requirements of the procedural protections provided by the Administrative Procedure Act?
No.
I disagree strongly. I do want to say that members of this committee, including myself, will continue to provide oversight to the Bureau and ensure that we make the Bureau responsive to the American people. My time's expired.